Hi, my name is Jubin with Dana Legal Services, and in this video we're going to talk specifically about what is a trademark and what kind of a monopoly or use protection do you get on the mark itself. Now remember, when I say trademark, I'm talking about marks in general, which may be trade related, like associated with products and goods, or they may be related to services, so it could be a service mark. Again, the question is, what kind of monopoly do I get on the word? So remember, trademarks, the purpose of trademarks is to help the consumer of the goods or the services. It's to help the consumer understand the origin or who is putting out the goods or the services, so that if there's any issues or concern, they know where to go. So they don't want the consumer confused between two people. So someone may be putting out a product under a particular name, and it's a good, great quality product. And then someone else may be putting out a very cheap, replica of the good product under the same name and selling it to the consumer. And the consumer is now buying the product and thinking it's the good one, but it's actually a fabricated one. And now they're all confused. So that's what the trademark laws prevent. So from people knocking off goods, a lot of that happens in the fashion industry when it comes to labels and brands. Some people know that a Louis Vuitton bag is worth a lot of money. They'll use cheap products, cheap manufacturing processes, get the product out for a lot less, but make it look like that bag and try to sell it to people so they think it's a genuine Louis Vuitton bag. That's just an example. So, do you get a monopoly on your mark? The answer to your question is, well, monopoly isn't a good word. Do you get exclusive use of that mark on your goods and services? The answer is yes, for the goods and services you identified when you filed your trademark application. Remember, when you file a trademark application, you have to have three things. One, you have to have the mark. So you pick a name. Two, you have to have goods and services that you're going to use that mark with. And three, you're going to have a date of first use, or you have to have plans to use it. So once you identify your mark, and assuming that no one else has it out there, and you identify your goods and services, then those two things combined can be a basis for which to register your mark and get your trademark. Once you get your trademark, you have basically exclusive use of that word or those group of words for those goods and services. So if your goods and services are printers, then you have a mark that can be used on printers. Now, can somebody else go use your exact same mark on clothing? That's what the trademark office tries to differentiate between. That's why they require you to identify goods and services by class, so that people can use the same label as a product for different classes. And they're different companies, and they own it differently, and they have different registrations. So if you have a mark for printers and someone wants a mark for something totally different from printers, let's say t-shirts, then it's quite possible that both marks can exist at the same time. What I'm getting at is this: you have exclusive use of your mark for the goods and services. If you don't want anyone to have it in any other class, which you might be interested in, then there's a lot of things you can do to prevent that. One would be very costly, which is file a bunch of trademark applications, or one trademark applications in a bunch of classes. Remember though, you have to actually use it or plan to use it. So you can't file for your mark for printers and also for shoes just to prevent other people from getting shoes. If you don't use it for shoes, they won't allow you to register it. So remember this: trademarks are mark and goods and services combination. If someone wants the same mark for an entirely different goods or services, and it's not likely to confuse consumers. So for example, someone buying a printer wouldn't think that the person selling the printer also sells t-shirts. They might think of those two as two separate companies. On the other hand, someone buying, someone having a mark for printers might be considered similar to someone selling computer products. So they may not allow you to register the same mark for printers as they do for computer. Even though computers are different from printers, they're closely related. And there's a lot of examples in the industry where people are actually making computers and making printers. For example, Hewlett Packard, HP. There's HP computers and there's HP printers. So because those two industries are crossed by one particular brand, it might be that other people won't be allowed to do it. Anyway, bottom line, look at the class of goods you're identifying, look at your mark, and if that combination is unique and you plan to use it or are actually using it, then you can get your trademark registered. You have monopoly on that mark for those class of goods and services. My name is Jubin Dana with Dana Legal Services. That's a wrap on this idea of trademark. Here's our contact info. Reach out. We do free consults. You can ask us questions. We can understand your situation, give you some good advice, let you know what your options are. And then if you decide to move forward with this, we'd be happy to help you. Take care.